Welcome back to Real Estate 101. Today we're going to continue our discussion on family law and talk a little bit about case conferences. And I'm pleased to be joined once again by Todd Slonim of Devry Smith Frank LLP. Todd, welcome back to the show.
Pleasure to be here.
All right, Todd, so normally in a case conference, there's usually a first meeting with a judge. What's that meeting about?
Okay, so in family law proceedings in Ontario, the first date before a judge is supposed to be a case conference. A case conference is an informal meeting among the parties, lawyers, if the parties are represented, and a judge. And the case conference can be held in chambers, or in a meeting, or in open court. It depends on which jurisdiction you're dealing with.
Okay, now how long does it take to schedule a case conference?
It's a good question, and it really depends on jurisdiction where you reside. You can't forum shop with courts, and so it really depends where the parties and the children live. Case conferences can take as little as 6 weeks to schedule, or it could be as long as 6 months. So unfortunately, you don't get to choose the jurisdiction, so there can be a significant difference in timing depending on where you live.
Okay, so what exactly is the purpose of a case conference?
So the main focus of a case conference is to have a meaningful discussion of the issues in an open way with the judge, who acts like a mediator, although he's an official judge. At the case conference, you can deal with procedural matters. So you can look into issues that deal with disclosure, that is, issues that relate to information that you're seeking, be it documents or information. You can look to timetabling of events, next steps of a case. You can look at what evidence you may require in terms of expert evidence or expert reports. Look at ways of settling issues. What issues are controversial? What issues are in dispute? Which issues are not in dispute? Are there ways that you can resolve that with the judge and the party? So it's a real opportunity for the parties to engage in meaningful dialogue.
All right, so what materials, if any, are required to be prepared in advance of the case conference, and who prepares them?
Okay, again, another very good question. In advance of a case conference, the parties have to produce a case conference brief. The applicant and the respondent both have to prepare these materials. And it's an opportunity to provide the judge with your side of events, but focusing on the issues that can be dealt with at the case conference. The judge wants to hear what the issues are ultimately, but you have such limited time that you can only really focus on a few areas, and those are the areas that you really want to focus in your materials. With that brief, there may be a financial statement, an updated financial statement, and these are all materials to provide a meaningful dialogue for the judge as well as for the parties.
Okay, so what materials is a judge looking for in order to make a case conference more productive?
Well, the materials themselves do have to be concise. A judge doesn't want to see you rambling on issues. They want you to get to the point. They want you, again, to focus on the issues that can really be dealt with that day. That is helpful for the judge because that creates structure.
All right.
If there are 10 things that have to be dealt with at generally in the overall context of the family law matter, on that day, perhaps only 3 of them may be able to be dealt with. That being said, the case conference is a good opportunity to speak with the other side and see what can be resolved outside of the case conference itself and perhaps in the halls of the court.
Okay, now for these case conferences, are there resolutions, are there results, like does something happen?
Well, again, another good question. If the parties are working diligently and working together in sort of a positive way, often many issues can be resolved by way of a consent. And that is an agreement that the parties agree to on specific terms. So again, it could be usually it's very procedural, but it can go beyond that. Sometimes this is really the first opportunity for the parties to have a dialogue, and they haven't spoken. And so some of the issues that they thought may have been real issues actually are quite or easily resolvable. In terms of what the judge can do, he can order procedural orders, again, as we spoke about the issues of disclosure, timetabling, and make any procedural order that he thinks will be helpful in advancing the case towards resolution. What he can't do is make substantive orders. Those orders that deal with support, custody, access, property. That has to be really dealt with in a different form, unless, again, it is on consent.
Right. Okay, so in your experience, is there anything that you shouldn't do? Is there anything that a client or a lawyer, for that matter, shouldn't do in a case conference that may hinder some sort of result?
Well, there's a duty for the parties to show up to the case conference. So it would be a mistake for a party to believe that their lawyer can deal with it and that they can stay at home.
And they don't show up.
And they don't show up. You can get quite a significant comments can be made from the judge. The idea here is that it's again an opportunity for the parties to enter into a discussion, and the judge wants to hear from everyone. And a lawyer representing the client may not have the instructions available to him if his client isn't there. So there are rules that do require parties to show up, to have meaningful discussions. Another important element is to be prepared. Have your documents drafted. Have the materials served in advance according to the timelines. If you're the applicant or you are the party who has requested the case conference, you have to serve your materials 7 days in advance. If you're the responding party, you have to have them in 4 days in advance. And that's to assure that there's a natural flow of the court process. People want to be able to have meaningful discussions, they want to be able to enter into that kind of dialogue, and if they're not given an opportunity to review documents in advance, it really stifles the type of communication that you can have at the case conference. And if that is the type of way you want to advance a case, a party could request from a judge that that the party who's, let's say, offending the rules of court, or for our purposes, the family law rules, could seek cost against you. Now, that's highly discretionary by the court or the judge, but it has been known to happen, and one has to be mindful of that, because you don't want that on the record that you've been subject to a cost order.
Okay, Todd, so for today's final question, what should somebody do that they may be going into a case conference or may need, they're just starting their family law proceeding?
Well, I think it's always helpful to have legal representation. Court can be stressful, and you may not know how to present your case. So having a family law lawyer to help you through a case conference can be quite meaningful. The issues are: be prepared to be resolution focused. That is the ultimate way of resolving your case. It reduces fees and reduces stress. If there are things that you're willing to, let's say, compromise on or enter into discussions that allow for a resolution, then bring that mindset to the case conference. Help the judge understand the issues. Why are they meaningful to you? Why are they important? Don't try to accomplish everything at the case conference, but try to accomplish those meaningful aspects of the case that a judge can help you with.
Can deal with, yeah.
And take direction. The judges will give direction and at times give opinion on issues. That is suggestive of, if this matter goes forward and let's say you have to go to a next step, let's say a motion or another conference, the way a court might see the issue. And so the judge is giving you an idea of ways to resolve it, or that you could be exposed if you're on the wrong side of an argument. So it's about listening, adapting, working with the other parties. It's often difficult in family law, but if you take these steps, you can reduce the stress and reduce the cost of your family law proceeding.
All right, Todd, great stuff. Thanks for coming on today's show, and I hope to see you again sometime down the road.
Thank you for having me.
So if you're having any issues with case conferences or need the help of a family lawyer, get in contact with Todd Slonim of Devry Smith Frank LLP. I'm Joe, thanks for watching, and we'll see you next time.